5 seconds to go. Start. Provided such age determination test conducted on the order of the committee or the board shall be completed within 15 days from the date of such order. Stop. Para. The age recorded by the committee or the board to be the age of person so brought before it shall, for the purpose of this act, be deemed to be the true age of that person. Stop. Para. This court, after referring to the fact that there was no other document contradicting the date of birth as shown in the matriculation certificate, held that the medical evidence was not required and thereby upheld the order of the High Court affirming the judgment of the Sessions Court as well as the Juvenile Justice Board. Stop. Thus, the decisions relied upon by the learned counsel appearing for the respondent accused should be looked into and appreciated as aforesaid. Stop. The decisions do not help the respondent accused in any manner. Stop. On the contrary, the ratio discernible from all the decisions discussed above, is that the credibility and acceptability of the documents, including the school living certificate, etc., would depend on the facts and circumstances of each case, and no hard and fast rule as such could be laid in that regard. Stop. Para. In Prague Bhati Supra, after referring other decisions, this court held as under, para. It is no doubt true that if there is a clear and unambiguous case in favor of the juvenile accused that he was a minor below the age of 18 years on the date of the incident and the documentary evidence at least prima facie proves the same, he would be entitled to the special protection under the JJ Act. Stop. But when an accused commits a grave and heinous offence and thereafter attempts to take statutory shelter under the guise of being a minor, a casual or cavalier approach while recording as to whether an accused is a juvenile or not cannot be permitted, as the courts are enjoined upon to perform their duties with the object of protecting the confidence of common men in the institution entrusted with the administration of justice. Stop. Para. The benefit of the principle of benevolent legislation attached to the JJ Act would thus apply to only such cases wherein the accused is held to be a juvenile on the basis of at least prima facie evidence regarding his minority, as the benefit of the possibilities of two views in regard to the age of the alleged accused who is involved in grave and serious offence which he committed and gave effect to it in a well-planned manner reflecting his maturity of mind rather than innocence, indicating that his plea of juvenility is more in the nature of a shield to dodge or dupe the arms of law, cannot be allowed to come to his rescue. Stop. Para. The dictum of the aforesaid is that the purpose of the Act, 2000 is not to give shelter to the accused of grave and heinous offences. Stop. Para. This court in several of its decisions, including Ramdev Chauhan alias Rajnath Supra, dealing with a similar situation, which fortifies what we have stated, observed as follows, para. It is clear that the petitioner neither was a child nor near about the age of being a child within the meaning of the Juvenile Justice Act or the Children Act. Stop. He is proved to be a major at the time of the commission of the offence. Stop. No doubt, much less a reasonable doubt is created in the mind of the court, for the accused, entitling him to the benefit of a lesser punishment. Stop.